हाँ किसको कैसे करना ठीक है ठीक है हाँ वो तो सिर्फ इसी में आप आइए चलिए आगे में ठीक है
Yeah, I'm extremely sorry for all these inconvenience. No, now we'll start this session, and I think I'm live in all other Facebook and YouTube channels, right? Yeah.
Yes.
Yeah. So thank you, Gayatri. I'll start my topic for today discussion, and then I'll just introduce myself again. I'm Mr. Sonal Tiwary. I'm practicing advocate in Jharkhand High Court. I am also working with Human Rights Law Network in Jharkhand, and we basically provide pro bono legal service to the needy and the marginalized community in the state of Jharkhand, to the people who have been affected because of the, I would not mind saying government repressions or any corporate repressions and all those things, right? So I'll do one thing because the topic which have been assigned to me basically deals with NAREGA, and then I also need to cover about fundamental rights. But since Mr. James Herons is with us, Mr. James Herons is the another speaker who is an expert in NAREGA and is the convener of NAREGA Watch. So I really would not like to intervene in the NAREGA thing, but I'll just point out one thing I'll just point out one thing, and I would like to start wherein I'm just requesting all those law students who have joined with us that try to do something during your law school itself. Now, why I'm saying this, because I think we, being a law student, we need to understand the importance of Article 32 and then Article 226. And this is like a craziest thing any constitution has got, right? So now I don't need to explain you as to what is Article 32 and 226, but I'll tell you one thing, that any citizen in this country can approach directly to the High Court or the Supreme Court of India whenever there is a fundamental right violation by the state, which we have to remember, right? By the state. It's not that if any private company violates, it's like you cannot approach to the state, but there are instrumentality tests and all those things under Article 12, which we can discuss in another session. So I'll do one thing, that what we really need to understand being a law student is that the law, whatever we are studying, it is not only for हम पढ़ के मतलब रख लिए या रट के पढ़ लिए खत्म कर लिए, right? What I'll suggest, try to use those things as much as possible by meeting all those people, right? Now, for example, when you are traveling in bus, just start having conversations with the senior citizens as to what kind of problems they are facing. Now, everyone knows there is a law called Senior Citizen Act, which provides different rights to the senior citizen and all those things. Maybe start talking to the children as to what kind of problem they are facing, right? So I'll tell you one very good example wherein in Jharkhand High Court we have intervened in the High Court through a PIL by a law student of National University for Study and Research in Law. Her name is Gursimran. So she has filed a very good PIL in Jharkhand High Court wherein she is demanding that women helpline number, which has not been started yet in the state of Jharkhand, should be implemented in the state of Jharkhand. So I'll just give you a brief fact about this case, that when the Nirbhaya thing happened, and then when the Nirbhaya fund was created, in the J.S. Verma committee report, one of the point laid down by J.S. Verma was that women helpline numbers should be started all over the country. Now, for example, we have 100 number, 100, which wherever, like if you are in Jharkhand or if you are in Delhi, the number is same, right? So in the same way, the central government said, Ministry of Women and Child Development said that we need to have one universal number for women helpline, and that number is 181. And I hope in different states it has been implemented, but in the state of Jharkhand it wasn't implemented, and Jharkhand government has received almost 34 lakh rupees for that, but they never invested that amount. And the amount was given to them in the year 2014-15 itself, but they never utilize that amount. So what I'm suggesting is that, see that a fourth-year law student is coming to the court and asking the honorable court to direct the state government that 181 number, that means the universalization of women helpline scheme, should be implemented in state of Jharkhand, right? So since all of you are law student, most of the participants are law student, what I'm suggesting is that try to find out something, some problem, or wherein law students can intervene. Very simple example I'll give you again, that all of us are aware about the solid waste management rules 2016, which says that all those companies which are manufacturing napkins and pads, they need to provide a pouch also for the disposal of those napkins and pads. Now everyone can tell me all of those all those, that whether they provide disposal bags. Not at all. Try to file a simple public interest litigation on this subject, saying that the court must direct the state government to direct the companies that they should provide, because they are not following solid waste management rules, right? And one thing always try to remember is that rule of law is higher than everything. Rule of law, I'll just repeat, rule of law is higher than everything, and constitution is the mother of every subject. Just remember this and try to connect everything with the Indian constitution. Indian constitution has been drafted so well. It's like in my final semester, I also read comparative constitution with taught by one of the best teacher, Mr. Girish Casey, wherein he has taught us about different constitutional perspective. But I can tell you that the finest constitution is Indian constitution. Now, another more PIL which was filed in Jharkhand High Court by a law student, wherein he's praying that the Jharkhand Human Rights Commission has there is no chairperson in this commission. So there is no chairperson in the Jharkhand State Human Rights Commission for the past 3 years. And now this guy wanted to apply for internship. When he went to do internship and all, he saw that there is no chairperson. Now let's a very simple thing, no? A very simple thing wherein he's filing a PIL and he's asking the court to direct the government to appoint a chairperson. So this is what a PIL can do. And I'd love to explain as to how we can really use the platform of the court. And it's not necessary that a lawyer is required for everything. A law student can intervene. I remember when RF Forest thing was going, a law student from Jamshedpur, Tata itself, though he is studying in Delhi, wrote a letter to the Chief Justice of India, and the matter was taken cognizance, right? The matter was taken cognizance by the Supreme Court of India. So I think we must use this being belonging to legal fraternity. Now, I'll also tell you one, maybe James sir will explain you on that, but I'll just add few things in the NAREGA Act. Now, if you look into the sections of the NAREGA Act, it says that the government has to provide wages, NAREGA wages. And if you look into the data, the NAREGA wages are less than the minimum wages. Now, this is very important, that whatever government is paying under NAREGA wages, it is less than the minimum wages, which has been enshrined in the Minimum Wages Act. Can't a lawyer do something on this, or can't a law student do something on this? A simple PIL is to be filed in any court. And I'll tell you, petition has already been filed in the Karnataka court, and then that matter is also pending in the Supreme Court of India, wherein a person has approached saying that, because if you'll also look into the different judgments which have been pronounced by the Supreme Court of India, it says that if any person who is receiving less than minimum wages will be termed under bonded labor. So it means, in one hand, you are providing me, you are saying that you have right to work under NAREGA, you will get jobs and all those things are very, they are showing everything that you get everything. But on the other hand, I have been termed as bonded labor. So this is very important, and this can be only explained when you are working in field, when you talk to the laborers, when you meet those laborers who are working in the who are working under the NAREGA, right? So I think that it's very important. It's very important that the student must get engaged in the legal aid clinics and have conversations with many with all these stakeholders, right? Now, I'll tell you about few provisions of fundamental right, because it is very difficult to explain you in this aspect in this 1 hour session. So I'll just tell you a few important things which every law student need to understand. One is Article 12 of the Indian Constitution. It is very important because if you see fundamental rights, the chapter starts from Article 12 to 35, but Article 12 and 13 does not provide any fundamental rights to us, but it defines the word state, because fundamental rights are available against only the state. And then there is a risk, there are Supreme Court judgments, very beautiful judgments, wherein they have interpreted the term state to include many stakeholders, right? So I'm yeah I'm I think that everyone is aware about State 12, and I don't need to explain instrumentalities and all those things. One very thing which I want to explain you under Article 13, Clause 3 of the Indian Constitution, which defines law, and why it is important to understand the term law is, now, for example, the discussion was going on relating to triple talaq and all those things, right? So one very important thing is that everyone needs to understand, because I have seen being when I speak to my Muslim friends, no, they always say that we can marry 4 women and then the Hindu guy cannot marry. So one of my Hindu friend was saying that it's violative of Article 14, but you need to understand the definition of law for that. Now, Article 13, Clause 3 of the Indian Constitution does not includes the personal law. So in personal law, you can be discriminated, which is very important. I think every law student must understand this. Then coming to Article 14 and all those things, I'll not get into detail, but I'll just tell you one very fine example which I have, which when I went to one of the village in Jharkhand, so there was this village wherein when I went, so in that village, actually the discussion was going on, wherein one of the male person said that in our village there is a pond wherein in one side men take baths and on the other side female takes bath. So he was saying it is under Article 14, and since everyone is equal, it is possible that we both can take bath in the same place. So that such kind of examples you'll get when you go to the fields and all those places, right? So it's very important that we must understand the true meaning of Article 14. It's very important. And I have always said that in order to understand Article 14 of the Indian Constitution, just remember one thing, that think that there is a stadium wherein you have called and you have invited persons from disabilities, female, children, senior citizens, blind, and everyone to come and have a race. Now, if we see that, that's a perfect equality, but is that correct? Is that a real equality? Not at all. That's what you have to understand reading into Article 14. And then there are Supreme Court judgments which have interpreted the Article 14 in like classification test, arbitrariness test, and then even it includes principle of natural justice test, right? And then there is 15 and all those other articles. I'll also talk about Article 19 and 21, which I think that these are the most important provision, and Article 21 is like one of the best provision in the Indian Constitution. You also need to maybe whenever you get time, you just need to really get into detail with the concept of due procedure in USA and in India, and I think that is also very important. Then Article 29 and 30, finest thing, providing rights to the minorities, because this is also a huge debate in every corner of the India. Then Article 32 that talks about providing constitutional remedies approaching directly to the High Court. Now, I'll try to tell you about few cases which I have done in Jharkhand High Court, and I intervened in those cases when I was a law student only. So I'll just tell you one very good case, and maybe in chat box, if you guys feel free, you can just write and let me know that do you feel that these kind of projects should be allowed in the state of Jharkhand or in any part of the country. So actually, there is a company which is trying to establish one power project in Jharkhand. Now, this company plans to import coal from Australia. So the coal will come from Australia first to Orissa. To ship, it will come to Orissa. Then through roadways and railways, the coal will be brought to Jharkhand, traveling another 1,000 kilometers. Then the coal will be processed, electricity will be generated from that coal, and then this electricity will be exported to Bangladesh. Now these kind of power projects are coming in the state of, and in many other places these kind of power projects will come. Now just in chat box, if people can write, do you think that these kind of projects should be allowed, wherein companies trying to import coal from some other country, companies trying to export electricity to some other country, and companies trying to create pollution in India, pollution in Jharkhand? Do you think so? I wanted to say this because everyone here needs to also understand the concept of public purpose and the Land Acquisition Act, and many other things are connected. Environmental thing is connected, right? And I can also talk about a little bit about preamble, because preamble is like amazing thing of the Indian Constitution, though there was discussion as to whether that is part of the Indian Constitution or not, which I feel so sad that these kind of discussions have gone previously as to whether preamble is part of the Indian Constitution or not. Obviously, preamble should be the part of the Indian Constitution. And how much time I have taken? 15 minutes more. Yeah. So I'll try to cover few things relating to wherein I can explain you as to how you can file public interest litigations, how you can file writs, being a law student in your respective high courts, or how you can file complaints in National Human Rights Commission and all this. Just remember one thing, that in India, one thing which is very important is that in order to build your case, you requires everything in written. All these oral conversations will never matter. I went to the deputy collector and I spoke, that will never matter. But when I write later to deputy collector, that matters to the court. When I write later to the chief justice, that matters to the court. So I think every one of you, just remember one thing, that whenever you are building your case, any case, have a written conversation and try to use Indian Postal Service. In the sense, try to have a copy of proof that yes, we have sent representations. Now and also remember one thing, that any matter which is relating to Article 226 or 32, the representations must be sent to the government bodies. You cannot send letters to the private bodies and then go to the court asking them to direct something to these people, to the private companies, right? So just remember first thing, that whenever you think that this matter is very important, this matter is a public purpose, or I can help this person, have anything in written. Start writing letters. I hope everyone knows about how to file RTIs. Just use RTIs. Find out the details. So there were interns in our office. With the help of with those two interns, we managed to file 2 RTIs in Department of Women, asking how many trafficking cases have been registered. And you won't believe, a simple RTI was filed, but I received almost 30 letters from all the superintendent of police of state of Jharkhand, of different districts of Jharkhand, sending their reply that these number of cases have been filed under trafficking. So maybe you can use those data also in order to build your case very strongly. Now, when you have everything in written conversation, when you get everything in written, the next thing is that drafting. And the drafting is very simple. one thing which I remember from Fali Nariman when he was interviewing in some new channel, he said drafting a plaint can take you a month, but drafting a PIL or writ is like a 2 hour thing, 2-3 hours thing. So practicing in lower is very different. Practicing in high court is quite easy compared to lower courts. Drafting basically involves your cause of action and what remedy are you seeking. The most important part under the drafting is the prayer thing. What are you praying for? Now, for example, when Gursimran filed PIL in Jharkhand High Court, directing the court to implement the universalization of women helpline scheme, the prayers were implementation of universalization of women helpline scheme, to direct the state government to complete the tender process of universalization of women helpline scheme. So these kind of prayers, and these are very simple. You don't need to be like put it in a very fancy language. And remember one thing: whenever you draft, whenever you send letters, just keep in a very simple language. No need to be very no need to use fancy languages and all. But it's like always appreciated that if you use all those all these things. But yeah. And then when you file matter in the Jharkhand High Court, then you will be called, and when your matter will be listed, a law student, when you file matter, either in you can file it petitioner in person, or you can file it through an advocate. Petitioner in person means a person can go and directly talk about his case without seeking any assistance from a lawyer. He does not require any lawyer. And when you take a lawyer's help, the lawyer will argue on your behalf. Now, what I will suggest everyone, and almost 73 people are here in Google Meet, what I'll suggest is, I'll also share my mail ID and then my contact number, maybe from wherever places you belong. And if you feel that any matter which is of public importance, or you feel that this lady requires help, this child requires help, this senior citizens require help, this person with disability requires help, you can approach to us. We can help you in filing the petition, and we can move to the court if required. We can also move to the Supreme Court of India. So that is also important. Yeah, I have seen that I have received messages in Facebook Live and other places. I have not received any message in Google Meet regarding whether that project, but I have received few messages in Facebook Live wherein people are saying that, yeah, the project is not good and all those things. So
That we can ask.
Huh?
That we ask.
Yeah. So if anyone till now, if anyone have any doubt, if you please ask me. Like, yeah, please ask me.
I've got some interesting questions.
Yeah, please, Gayatri.
One is by Rajat Anand.
Yeah.
So he's asking, can we file a PIL against a private college for concession of fees during pandemic?
Who are taking fees during the pandemic, right? So, Rajan, are you a law student? Yeah, if Rajan is listening, if Rajan can listen to me, are you a law student, Rajan?
I got this question on chat.
Okay, no problem. So I'll tell you one thing, Gayatri and Rajan, that one thing which we need to understand, that the courts are also reluctant to intervene in policy matters. Now, for example, the government of India publishes annual budgets, and the budgets discriminate, saying that senior citizen will this much amount, this person, and all those things. All slabs are there, right? Can you go ahead and challenge in court? We cannot challenge the policy matters, which you have to remember. And I'll tell you one of the recent experience, which I in the matter which I filed in Jharkhand High Court. So there was this matter wherein I prayed for that. There are Jharkhand government is managing almost 400 to 500 residential schools in Jharkhand, and Supreme Court has taken suo motu cognizance, and even the government has given direction that Utkramit Madhya Vidyalaya, all these day scholar schools who provides midday meal to their student, should either provide food security allowances or provide ration to the students. Now, for example, I am a student. I am a student of residential. I am a student of day scholar, Utkramit Madhya Vidyalaya. Teachers are providing me ration, and if teachers fail to provide me ration, the government is providing me food security allowances as per midday meal scheme. Think about the another slab. I am a student of residential school. I also belong to the same age. I residential school like Jharkhand High Vidyalaya, Kasturba Vidyalaya, and all those things. And I was getting 3 times food in that school, but because of the lockdown, I have been sent back to my hometown, and I'm not getting anything now. Right? I'm not getting anything. I am more vulnerable now. But in that case, the Honorable High Court of Jharkhand said that this is a policy matter which we would not like to intervene. So we also need to understand that. Yeah, I'll also update with one more PIL which we did during the lockdown or during the COVID-19 lockdown that was relating to the welfare for the transgender. So in Jharkhand, we have 13,000 numbers of the transgender population. And because of the lockdown, they were not able to earn their livelihood. There was no facilities for them. We filed in Jharkhand High Court, and Jharkhand High Court directed the state to provide ration, and also directed that every transgender should get ration card, at least the benefits of the ration card. So that was there. Yeah, Gayatri, any other question?
Yeah, I've got one, but it's slide of conversation. It's by Mabupi. He's asking, Supreme Court says that reservation is not a fundamental right. What do you think about this?
Yeah. So there is a quote that सुप्रीम कोर्ट फाइनल इसलिए है क्योंकि वो फाइनल अपेक्स कोर्ट, अगर कोई सुप्रीम कोर्ट से भी बड़ा रहता तो सुप्रीम कोर्ट फाइनल नहीं होता. And now once if the Supreme Court is saying that, I think that's one kind of observation, and we also need to understand Article 142 for that, which says that any judgments pronounced by the Supreme Court becomes law. But you also need to understand one very finest thing is that any judgment pronounced in any particular case is bound between the two parties, and the same facts and conditions has to be established in order to apply for the other case, right? When I'm saying that it is applicable, it will be applicable in doctrine of precedent, it means I also need to have same facts, same set of facts, right? So if you'll ask my opinion for this particular observation by the Supreme Court, I can say you one thing, that the recent judgment of Andhra also, wherein Justice Misra said that reservation will not extend in scheduled area. So 100% reservation does not extend in scheduled area for scheduled tribe teachers. That was another judgment. So what I see is that still I think that tribal communities and these communities needs reservation, because maybe for example, I have seen my friends talking that, see, he's the son of IAS, why does he need reservations and all those things? But why are we just saying one people? No, we need to visit the field and see their conditions. So I feel that we must understand in that scenario also, and in that way, I can tell you that I think Supreme Court. I being a lawyer, I cannot say that, but yeah, I think everyone can understand indirectly.
There is one question. If policy decisions are violating fundamental rights,
if policy decisions
are violating fundamental rights?
Yes, this is a very good question. I'll tell you one thing, that if we look into the constitutional provision, it says that the state cannot make any law. Now, law has been defined under Article 13 Clause 3 as to what all things can be included. But if those policies violates fundamental rights, we also need to know and understand what fundamental rights it violates as to the proportionate of infringement, I'll say. So there are different theories for that, but just remember one thing: if the policies violates the fundamental rights, you have got every remedy to challenge it. And remember one very important thing: never ever care that since this is a policy decision and we cannot intervene, just file a PIL, just file a matter, see as to as to what court is up to, right? It depends. Sometimes I will not sign. I will not mind saying that Supreme Court has intervened many times in the political, in the policies matters and all those, all these matters. So if there is such instances, please approach to the court. And remember one thing: it's judiciary which is the final interpreter. So maybe any whether legislative or executive, if they frames any policy, that can always be challenged in the Supreme Court and in the High Court of India, in the High Court of different states. Any other question, Gayatri?
Yes, sir. I got one last question. It is about labor law amendment. He's asked APNA Sarkar. It's by APNA Sarkar. The question is, to what extent will the labor law amendment push the Indian economy, and what do you think about the labor law amendment?
So labor law amendment, I'll say it's a joke now. The situation is so bad, and the government is trying to do all these nonsense stuffs, right? I'll not mind saying nonsense stuff, and I'm also I also know that when the UP government and then Karnataka government tried to make certain amendments, and I think these two amendments have been withdrawn also. I'm not sure, but yeah, regarding the changes which were made, some things they have been withdrawn. I have not done a detailed research on that, but I find it and different. It has already been challenged in state of UP, and it has already been challenged in High Court of Karnataka. So we'll just see. We'll just wait for the final decision by the court, and we'll see. But I think it's the high time that all these, because everyone has seen the problem, right? How these people came back, and this indicates that none of the laborers are dependent on the government. So how is government trying to regulate them? Which I think all of you should understand this.
I think so.
Yeah. I'm available at. I'll share my details, and thank you everyone for your presence hearing. If you have any doubts, please write it to me. We have lawyers in every part of the country. HRLN has lawyers, and everyone will help you. Thank you, everyone.
And I would like to offer our heartfelt gratitude to you, sir. We are grateful for your time, sir, and efforts you took to share your thoughts and experience. They were remarkable. Thank you for joining us. In continuance of our conversation on the topic of implementation of national rural employment guarantee,
Nice.
I would now like